I choose today to discuss the concept of white-collar crime. Obviously, what stands out with a white-collar type of prosecution is that 99.9% of the time there is no actual physical violence, no dead body, no individual injured. The jury will take a look at white-collar crime and will make a determination, of course, based on the status of the evidence, that an individual accused of such an offense at such a high level of activity should not have engaged in the type of activity that causes one to be charged with a white-collar offense. Juries don't like a white individual charged with white-collar. Prosecutors will not prosecute a minor case dealing with white-collar. So in all probability you're going to have cases of white-collar infractions at a high level of employment or a high level of activity by, for instance, a boss, a VP of a company, things of that nature. Juries will take a look at the evidence and will make a determination as to whether or not there was intent to commit an offense on the part of the individual charged with a white-collar offense. In all probability, the individual is going to have to present a defense to include testifying himself or herself from the witness stand. And if there have been prior activities that constitute criminal infractions, that's the risk that the individual who is charged with a white-collar offense is going to take. Obviously, if in fact there are activities in the past, jurors will look askance at individuals that happen to be charged with a white-collar offense. And again, most of the time you're going to have individuals with prior activities that border on criminal activity. I've had individuals charged with white-collar offenses that take the stand, and inevitably the same pitfalls exist as any other defendant. There is a urgency on the part of the person charged with a white-collar offense who in fact takes the witness stand to declare to the jury, well, listen, I've never done anything wrong in my life. I've had that happen, despite admonitions pre-trial to the contrary. That opens a whole range of possibilities for the prosecution. Every activity that borders on criminal activity comes in to evidence with that blatant statement on the part of the defendant, I've never been accused of, or I've never done anything wrong in my life. I think it's important to obtain, I think it's important to obtain expert witnesses, people that are grounded in the field for which your client is charged, to be able to explain to a jury the activity from the perspective of the defendant, and to show the jury that there is no criminal activity involved, despite the fact that these activities did in fact occur. That is something that you're going to have to acknowledge, that the individual was engaged in the activity, but it was not criminal, either the nature of the activity or the intent of the defendant did not border on criminal activity. That being said, I urge any individual who has a client that is charged with white collar to immediately talk to an expert witness. Even though the individual doesn't testify as an expert, for the purpose and sake of getting educated in the field, talk to that expert before anything else happens. You can probably rely on your client for references of experts in the particular field in which a client is engaged. But by all means, know the pitfalls of putting the client on the witness stand, and knowing that you're going to have to put that individual on the stand should the state survive a motion for a directed verdict at the close of the state's case. Thank you.